redundant if you don't already know. Most of you met me on the tour. As Tasha said, I'm running for district attorney. I also run a nonprofit group, Americans Against Pretended Offenses. When we're done here with this set of speeches, I'm going to do a short 30-40 minute course on the history of trial by jury for the homeschool group that's shown up. Who wants to speak first here on that group? There's several groups here represented today. If I don't see any hands, I'll just pick Kelly. Kelly Patterson here. The applause is very much more is the head of Nevada Cop Block. I'm one of the heads. I'll let him tell his story. Go ahead, Kelly.
I'm a member of Nevada Cop Block. Cop Block itself has been in existence since 2010. Nevada Cop Block started in 2012.
Is Cop Block the organization that does the checkpoint places? There's gosh, I can't remember the word it's called, but there's a team of guys that I know go out when there's known DUI checkpoints and they practice exercising their rights. Is that part of Cop Block or some other organization?
People with Cop Block have done that.
Okay. I'm trying to think of the name they call themselves. It was cool. I'm gonna do it one time.
Peaceful Streets?
No. My friend Joe Duffy would know, I think.
So, as far as jury nullification, basically it's kind of a really simple concept actually, but the reason they actually set up juries in the first place is as a protection against government coming in and prosecuting people wrongfully. And the reason that they have the jury there is it's so that there's an impartial person within the courtroom that can rule basically like a referee, whether you're in the right or whether the government's in the right. So the reason that jury nullification is important is to maintain that neutral party that can rule on whether you're being persecuted or whether you've actually done something wrong.
Thank you, Kevin. Cindy, candidate. All right, we'll go here.
Okay. I'll volunteer. Hi, my name is Melissa. I'm with Southern Nevada Watchdogs. I work with Tasha all the time, as much as I can. So, what are you guys, like 12 at the most? Is that what I'm saying? 16, sorry. So, for most of you, when I was younger, at least one of my biggest concerns was justice. Okay, so if my brother came up to me and said, you have to play with me because I say so, and I don't want to, that's just not fair. Now, fair is not always what matters, but justice does. Justice is one of the last things that we have as people. We rely on justice. Justice is absolutely necessary in a free society. It's really unfortunate when a building like this can be so corrupt and does not represent justice. People don't even know how many people come to this building and don't get it. They don't get justice. More and more, police are arresting average, ordinary people. And it is spreading. People are beginning to understand that I'm not a criminal. Why am I being brought into this building? It is so important for people, residents, Americans, to know that they can actually be justice. They can bring it if they're on a jury. That's their responsibility. If the law is not fair, if it is not hurting someone, if just because a bureaucrat says, we don't like you doing this, so we're going to make you a criminal for it, doesn't mean that somebody should go to jail for it. Jury nullification and the jury is the last bastion of hope this country has in justice. So that's why it's so important, and that's why we're out here. Thank you, guys.
What's the website again?
www.snwatchdog.org.
I think candidate for County Commission Link is next. Cindy.
Thanks, everybody. I'm a homeschooler as well, and the thing I wanted to
there's no victim, there's no crime. You have the power when you sit on a jury to find the defendant not guilty and demand a jury trial if you're ever arrested and in trouble. Demand a jury trial because you have a right to a jury trial and a trial of your peers. Except for a misdemeanor, which we need to get together as groups and try to change that statute.
We can't change the law. The law already says, I'll get into that later, but the law already says everybody gets a jury trial.
Yeah.
Right, the law says everybody gets a jury trial, but our NRS statutes say only after a certain amount or, okay, so this is what we need to pursue in the legislature, which is coming up in 2015. One of our issues should be to hopefully, but again, that law is unconstitutional, so demand a jury trial is all I'm saying until we get that NRS statute changed. So that's all I have to say. I'm in Commission G in Henderson, Southeast Las Vegas, Green Valley, Boulder City. So hopefully you'll vote for me in November.
Woo! Team Matthew.
I think we have Team Matthew. I think they
I'd love to. Should I step into the...
step into the circle of speech, yes.
The circle of speech.
I need my... I can't talk without my pen here. Hi, everybody. I'm a trial lawyer. In fact, I'm the trial lawyer your mother warned you about. I'm actually a part-time comedian. But the truth is here, we're here to talk about the jury nullification. And the thing that's important to know is that if you're on a jury, after the closing arguments, after the instructions, and the judge tells you you have to render a true verdict according to the law and the evidence, once you're in the jury, it's secret. And I've been
Take some of the
years, and I've never once heard in the courthouse anybody say the words
Nullify.
or jury nullification. They just don't say it. But the point is, the jury nullification exists as a power. We have the right to do it because jury deliberations are secretive. Nobody gets to know what's going on in the jury room. Nobody gets to know who argued what or who feels what. But it's important to know this. But under what circumstances could you nullify a law? Well, if you think it's unjust, what would be an example of an unjust law? Something that says you got to do 10 years in prison for homeschooling. If I'm on the jury and they want to put someone in prison for 10 years for homeschooling, I would vote to acquit automatically. And you know the reason why it's secretive in jury deliberations? Because in America, voting is secret. If you're going to the polling place and voting, it's a secret. If you're in the jury room and you're voting, it's a secret. And so people don't get to know your motives, why you do something. If you see somebody arrested for selling marijuana, and I don't need that, but that's good, I'm good. If someone is arrested for selling marijuana, for example, I wouldn't convict the person. I just wouldn't do it personally. It goes against my conscience. And that's the whole point. You're essentially a conscientious objector for the legal system. You're saying, I don't go along with this law. The legislature makes the law, the executive enforces the law, the attorneys get paid a fortune to argue about the law. Well, what's our role as citizens? We get that final stopgap measure. Am I going too long here? We get to, if our conscience says so, we can vote not guilty. What would be another example? What if somebody were facing 10 years in prison for not buying insurance under Obamacare? Now, forgetting how you feel about Obamacare or liberals or conservatives, I don't think it's good to put somebody in prison for not buying insurance. That goes against my conscience. I'll give you another one. There's so many Mickey Mouse laws going on today. I feel kind of like Cindy. I used to avoid jury duty, but I'm looking for it now. They got so many Mickey Mouse cases. There's a guy arrested for collecting rainwater. Why? Because the water company wants to sell you water at a profit, and a handsome profit. So the person who's in charge of the water district today is going to be on the county commission tomorrow. It's a revolving door. If they're going to prosecute someone for gathering rainwater, I'm going to say, no, I'm not guilty. And there must be 1,000 examples. What about a compassionate Kevorkian situation? Someone's got a brain tumor from being on the phone too much, and they're dying, and they want to give them the final solution. They want to, it's kind of a sensitive topic, but I think people should have that right. Certainly, I'm not going to prosecute somebody. I probably exceeded my time here. Does anybody have any questions about this? I'd love to. Any thoughts, anybody? What it's like to be on a jury? Do you know what it's like to be on a jury?
Oh, I have a question.
Shoot me.
What will the judge tell you if you're sitting on a jury?
Yeah.
If you, that's the problem. I think we were talking earlier, is jury nullification, is it a right that we have, a right, or is it merely a power that exists? I don't want to use the word merely, but if you walk into a courtroom saying, I have the right to nullify, I'm going to nullify this law, if you're loud and proud about it, the prosecutor will just challenge you right there, or the judge may remove you for cause. Because the thing is, they don't want somebody going into a courtroom with a preconceived notion. And the short response is, I agree with the judge, because you don't want people to have bias. It's only after all the evidence has been in, after the closing arguments, after you've been instructed on everything, if you feel the law is bogus and you don't want to punish this person because you feel it's wrong, you have the right to conscientiously object and vote not guilty, and your vote is secret. So please tell everybody, I hope I'm not rambling here, but those are my thoughts.
What is it?
It's a form of prejudice, a good question, you know. They don't want people to go into court with their minds made up. And to some extent, it may be unfair to the accused if someone walks in, I'm definitely going to vote this way on the jury. But hear the evidence, listen to the arguments, you know, suffer the jury instructions, you know, and, you know, make your, anyways. It's just, you know, what I think is a real interesting question, I just throw this out to everybody. When a juror swears to render a verdict according to the law and the evidence, do they violate that oath when they vote? Well, maybe they do, maybe they don't, but ain't nobody going to know about it because, well,
right.
No, but well, they're.
That's
but,
right.
When
That's
you,
right. If the
Natural law.
law is unconstitutional, then you vote against it, then there's no problem.
That's
No,
right.
and I agree with you guys. I was just making the intellectual argument. Is it perjurious? Is it perjury to swear in court, I'm going to render a verdict according to the law and the evidence?
Yeah.
Then after all the law and evidence, that's kind of a baloney law. I think I'm going to vote not guilty. Did I violate my oath? I mean, maybe you did, but the point is, it's like a tree falling in the forest and nobody hears it. It won't count for anything because jury deliberations are secretive. So whether the oath is violated, I really don't know, but remember, how you vote is totally secret, and I think that's the most important thing to tell others. And if you want to do juror nullification, don't be loud and proud about it going into the courtroom, because they'll see that and they'll bounce you. They want to get a bunch of 12 uneducated people on the jury who will do exactly as instructed. That's what they want, is sheep on the jury. But anyways, I may have exceeded my time here, so thank you all for listening.
Do any of you understand what he meant when he said they'll bounce you? That means they'll exclude you from the jury. You won't get an opportunity to be on.
How can somebody really not be biased?
All right, folks. I have a couple of pages of notes. I want to go through all this with you and cover some basic history about the trial by jury. You guys know when it started?
I'm going to go 1215 Magna Carta, the Barons of Runnymede.
I'm going to say that's a good guess, but it actually predates them. In our system, that's pretty much the date. You guys know that before we had presidents, we had executives with unlimited power. It's kind of not much of a distinction anymore either, but they had a king that could do whatever he wanted, and around 1200, a bunch of the nobles, which weren't like common everyday people, they were the people that the king gave the privilege of owning land. You couldn't just own land without the privilege from the king. He gave these nobles the privilege of owning land, and part of that privilege was controlling the common people that served under. Well, this particular king, King John, was so evil and tyrannical that the nobles basically told him, look, we're going to kill you and put a new king in unless you change your ways. So they had this big kind of Occupy Runnymede kind of a deal, and out of it came basically a peace treaty for a war that never took place, and it was the Magna Carta. And there's only 3 provisions of the Magna Carta that are still left in force, and one of them is the trial by jury. The 2 most important provisions of the whole Magna Carta were this. 1, the king can't imprison or find anybody guilty without a trial by jury of their peers. Now before that, that wasn't the case. the king could appoint judges, and that's exactly what they were. The legislature was appointed by the judge. And if they voted a way he didn't want them to vote, well, they were no longer the appointee. Somebody else got in there, they were the appointee. And oddly enough, they all seemed to vote how the king wanted it to go. Because if not, well, somebody else will be in here and they'll vote. So I may as well vote that way so that I can keep my nice job in the favor of the king. This was a way for everybody to say, you know what? Even if the king gets completely out of hand, these 12 people have to find the person guilty. It was only put in there as a check against the king's power. If you look at the history of the whole movement, the whole Magna Carta was about limiting the king's power and putting some of it back into the, not back, but some of it into the hands of the people. The other provision that's in that is the nobles can agree to go to war with the king if he violates this agreement. They appointed a council of 25 nobles to get together and meet and see if the king was in violation of this. So there was really only two clauses that had teeth. One, we can go to war if you violate this new agreement. And two, you can't punish anybody unless 12 of their peers agree to do so. That became the kind of foundation of the English system for hundreds of years. And then when the colonies in America started, anybody know when that was? No. 1607 in Jamestown.
Kelly's so smart.
There was about 200 years of American settlement before the Revolutionary War. And all of that had this same tradition of common law. Most of the people who left England and Europe to come to America were political dissidents or people with religious beliefs that the king didn't look favorably on. Guys like William Penn, that's why we're here today. September 5th, you guys, that's today. It's the anniversary. I don't know how this one day is the anniversary of this entire case, but somehow, I don't know if it's the anniversary of being arrested or the anniversary of them starting the trial or ending the trial, I'm not really sure what. But somehow September 5th marks the anniversary of this case where William Penn, you guys familiar with Pennsylvania? Pennsylvania, the Phillies come from there, right? The Eagles. Before it was a state, it was named after this guy. This guy, before he came to America, was tried by the king back in 15-something, 16-something. He was tried by the king in a court with a jury for making an unapproved sermon in public. He was standing in the street telling people about his vision of God and conscience, and it differed from the king's version, and so they put him on trial. And there was a lot of dishonesty within the trial process. The bailiff actually, you know, you can't wear a hat in the courtroom, right? Well, so these guys knew the law very, very well. They were being persecuted. The bailiff says, put your hat on as they go into the courtroom. So they put their hat on. Then the judge finds them in contempt for having their hat on. And that's what they ended up putting them in prison for. Yeah. Because what they tried to do before all that was the jury said, we're not going to find him guilty of this crime. We're going to say, all they came back and said was, we find that he was speaking in the street, which is not a crime. They wouldn't go to the next step about what he was speaking, and the court's saying, the evidence before you, if you found that he was speaking in the street, you must find him guilty. That's what the law says. And all they would come back and say, we find that he spoke in the street. And so they imprisoned the jury, put them in prison, then starved them, and fined them. And they kept coming back. Have you changed your verdict now? Would you like your night in jail? Have you changed your verdict now? And after weeks of the verdict not changing, and the public now getting upset that they're doing this to the jury, he was kind of put into a corner where, all right, we've got to find him not guilty to avoid some kind of revolt. And so they found him not guilty on that, or accepted the jury's verdict on that, and then imprisoned him for the hat thing. So that's there's still a plaque now in England called Bushnell's case. Edward Bushnell was the foreman on the jury. And so it's called Bushnell's case, not Penn's case. I don't know if that has anything to do with the revolution or not, but that's what it's honored in England. Still, as today, stands for the proposition that the jury's power is the power to judge both the law and the facts. If you look, like I said, at Magna Carta, there's no way to really understand the provision that the king has to go through a jury, except that it's a check on the king's power to do whatever he wants. If it's just 12 people who have to do what the king says, it's really not much of a power to stop a war. So that's not what they intended. The Bushnell's case stands for the proposition, again, that it's the jury's power to judge both the law and the facts. Now, when we got over here, when the colonists got over here, my people were already here. You may not tell it, but I'm hard red. When we got over here, all that tradition came with it. And there was a case in 1730s of Wegner, a very similar case where he was prosecuted for telling true things about somebody else. And they were trying to convict him of seditious libel for saying true things about one of the king's agents who was corrupt. And the defense was, well, truth is an absolute defense to libel. And the court says, well, if you find that he said these following things against this guy that represents the king, you must find him guilty. And again, the jury said, not guilty, not guilty, not guilty. And it was one of the cases that happened 40 years before the Revolution. But it was one of the cases that was kind of the background of the train of abuses that they talked about in the Declaration of Independence. Let's talk about that. In the Declaration of Independence, you guys familiar with that? Yes? Yeah. It says a long train of abuses, the king has done all these things. One of the things the king had done was denied the people the right to trial by jury. So if you think about it, one of the things explicitly we went to war over was the king's denying our right to trial by jury. There were other things, but that was one of the things they thought was important enough to list. Then you go after the Revolution, we had the Articles of Confederation, which was a much better document than the Constitution. If you don't read the Articles of Confederation in your homeschool curriculum, you can't understand the Constitution. The Constitutional Convention was called to amend the Articles, and it was called for one specific reason. There was this inflation problem with the Continental. It seems they printed a bunch of paper currency and it had an inflationary effect. It's kind of hard for us to understand nowadays, right? But it was worthless, and so they were calling this convention to remove that power from the government to print money. And instead, the Constitutional Convention increased power in numerous different ways and ratified it without unanimous consent of the colonies, as was required by the Articles. They only did it with 9, and they basically forced the other colonies, hey, we've all agreed that we're going to be this new nation. You can go it alone, you small little rebellious states, or you can get on board now that we've pretty much decided who the majority is. And so the Constitution was done really almost as an anti-revolution. And we've gone downhill in a lot of ways since then. But the anti-federalists who were opposed to the adoption of the Constitution, they said we need to have a Bill of Rights. Otherwise, this Constitution is one of the most tyrannical documents that we can envision. And so they put in there the 7th Amendment, which I've written down here somewhere. I think. Here we go. The 7th Amendment in the Bill of Rights, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. That puts it in there. It was already in all the state constitutions. There was already a right to trial by jury in all the state constitutions. And this added it to the federal constitution just for good measure. In our state, we've got one of the best jury clauses in the whole nation. I know, it's very sad. The right of trial by jury shall be secured to all and remain inviolate forever. Now, a lot of legalistic terms and phrases have reasonable and kind of a balancing test. There's not a lot of middle ground or leeway in this. The right of trial by jury shall be secured to all and remain inviolate forever. But a jury trial may be waived by the parties in all civil cases in the manner to be prescribed by law. And in civil cases, if 3/4 of the jurors agree upon a verdict, it shall stand and have the same force and effect as a verdict by the whole jury. Now, that makes the case even stronger, because in according to contractual law, if you write out a declarative statement and then put one exception to it, the court's now going to assume that you considered all other exceptions and you carved out the one you wanted, right?
Well, yes.
Right? And if they had said nothing, it would actually be even worse, because then the court would say, they can't mean all. They can't really mean inviolate. It wouldn't be efficient. So they couldn't have meant all. Like when they say Congress shall make no law against freedom of speech, they don't really mean no law. They really mean the FCC should be kind of regulated. But the courts we were just in today, all right, did you guys see a jury box? It's not in there. I've filed briefs in those courts to try to get a trial by jury, and they won't give it to you. The statutes that create those courts say, and I don't have that one written down here, but it says in the statutes that create those courts, trials in these courts, the justice and municipal courts, must not be by jury. It's written right in the statute that creates the court, which means, frankly, that the entire court system, from the outset, conceptually, is in violation of the Constitution.
Yeah, what does that mean right there?
No free man shall be taken or imprisoned except by the lawful judgment of his peers. Paraphrase. Yeah. That's why we picked this spot. And there's been a systematic attempt over the last at least 100 years, to probably before that really, to pull back this power. If you think about the revolution, right? There was in 1801 Jefferson was elected, and it was called the Second American Revolution because the people were upset with how big and tyrannical the federal government had gotten by 1801. Imagine what they'd be saying now. I know they can't envision changes we've seen in things like Ferguson and police state and the NSA and empirical wars. But if they could envision it, they'd probably be against it. But the court, and from the beginning of the country, was composed of people who had been appointed by the king. To be a judge in 1774, you had to have been in the favor of the king, because he got to appoint and approve all appointees. So it was an institution that was already as loyal to the crown as one could get. So if there's gonna, and it grew and grew and grew. One of the worst cases for that was Marbury versus Madison, and the court tried to increase its power. And as part of increasing their power, they don't want the jury to be able to come in and check all the legal opinions that they write, because when they write case law, they're writing opinions on law, but they pretend they're writing new law. And then they follow it because somebody else wrote it 50 years ago, until they want to change it. Then the law evolves. Until then, it's a well-settled fact of law. And if it's really, really old, then they have to determine, well, that's kind of old. I don't know if that's still good law. So